Good afternoon, everyone. Welcome to the webinar on issues in valuation under IBC. Today we have with us IP Anju Agarwal ma'am, who will be sharing insights on issue in valuation under IBC. Participants, in last 15 minutes, we will taking question answer session. You can share your question in the box shown on the screen. Let me introduce ma'am first. Ma'am is an insolvency professional. She is an accomplished professional entrepreneur with a robust background in strategic consulting, specializing in instruction and a broad spectrum of financial services. Over 24 years career, she consistently delivered impactful solutions across sectors such as taxation, financial services, and legal compliance. Her journey includes a master's in economics and PGDM in marketing. Ma'am is deeply committed to empowering organizations in India and beyond, enabling significant cost savings and fostering competitiveness through innovative BPO and global delivery center services. Welcome, ma'am. Over to you.
Thank you. Thank you for inviting me. I'm very, I would say, grateful for Insolvency and Bankruptcy Committee of ICAI. And definitely, I will try to do justice like what you have asked me to do for. And let's begin. So I will just share my... Yeah. Can you see?
Yeah, ma'am. PPT is we
Okay.
can.
So, participants, so I am not aware what is the background of most of you. I'm assuming that it should be either chartered accountants or the people who have done this IC valuation registrations or courses and things like that. So I would like to first have one disclaimer that I am not a valuer by profession. But under insolvency, like when I got registered as insolvency professional and when we started working in under the law, we realized that valuations are an important part of the whole IBC process. And whatever today, like I'm presenting to you, uh, definitely from the, I would say, academic side of it, I will be sharing this, like I'm sharing this PPT, and there are certain academic aspects of the valuation. But again, whatever I would be talking about, it is more out of my own experience rather than any academic sort of understanding of things. So, with this disclaimer, like I would start. So, I would like you to have the questions also around the subject of insolvency and matlab in terms of insolvency and bankruptcy code only, because if you will ask me the technical questions of valuations, like how it is done or about the methodologies or about other things, I may not be do justice to those questions, because I'm not, see, I can always give you the practical aspect of it, but I may not do justice for the academic purposes. So please, like I would request you to have your questions ready in terms of the how it or what it entails in the IBC as insolvency professional for valuations. So valuations, as I said, that it is also, so we generally call that IBC has four pillars, which is like, of course, the IBBI, which is the board, and then the courts, NCLT, NCLAT, and then the insolvency professionals, and of course, the law itself. But I would say valuations are also an integral part of insolvency and bankruptcy code, because it helps many stakeholders to take decisions. And obviously, you will understand that if you will not take decisions, things will not move ahead. So, it is very important for that purpose. Now, when we talk about valuations, there are so many issues around valuations, that how to do it, who to do it, and what are the so earlier, as you know, that although we always had valuation courses and I would say, certifications for valuers, like how you will deal with the valuations, but not many standards were there. And now there are international standards, and they have been adopted by India also, uh, to be in the internationally appealable market. Because see, if you will not give people that comfort, that whatever money they are putting in, one, that it is safe, two, if it is, any stress happens, they can, kind of uh, take it back, or recover it back, and then on what basis they will get this money back. So valuation also plays a very important role there. So it was important for India. That is the reason, like, we had in the very beginning, Insolvency and Bankruptcy Code notified, and immediately after the code was notified, our international ranking for doing business had really shot up, and from there, consistently, the government is trying to do things which will make India an economy to attract maximum, I would say, FDI, to attract maximum businesses, or ideas, so that, like, economy develops. So to start with, in the IBC, just a minute, yeah. Mm, what is this whole gamut of valuations? So in the CIRP, there is a requirement under the law that the IB who gets appointed in the process, whether it is an RP or IRP or RP, they have to appoint valuers, right? Why? To see, like, so that the objective behind the evaluation is simple: maximization of asset value for the corporate debtor. And this is also very important for deciding or choosing the resolution applicant, so that, like, the maximum valuation can be, or maximum value can be achieved. For COC purposes, I hope, like, I'm sure you have all these terms with you. So CIRP is Corporate Insolvency Resolution Process under the IBC, and COC is this word for the Committee of Creditors, which is made of generally financial creditors. And if there is no financial creditor, then obviously, for with the operational creditors also, COC can be constituted. So if you have any particular question related to terms used during the CIRP, you can, let me know, and I will explain that. So for the COC purposes, because they have to approve the plan, any resolution plan, with the 66% of the voting share. So any valuation which is done under CIRP creates a benchmark, from, like, if so although I will be explaining it later, sometimes it is not necessary that the valuation should be the only benchmark for approving or disapproving any resolution plan. But yes, it provides certain framework for COC members to, like, to what extent a company can recover or can fetch valuation, or attraction from the investors. Then third is for the corporate debtor. Also, it is important because, say for example, if the directors are, although suspended from their powers, but they still, are very important part of the whole process, because they are the past of the company, and insolvency professional and the COC. So sometimes COC members may still have some view about the company, but insolvency professional who's taking care of the process definitely does not have any idea about that company, but in particular, like, for which that process is going on. So directors or the promoters or the, like, KMPs of the corporate debtor play very important role in supporting the RP in its decisions, and also the COC members, because corporate debtor is one person who exactly knows about the company and the whole valuation of that company, like what this company, although you may argue that they are the reason why the company went into insolvency or something like that. But at the same time, they are the people who know exactly in and out of the company as well. So they know like what value lies in the company. So they are also like very important to, because sometimes what happens, if the valuer is not doing justice to the valuations of the company, then obviously they do come in the picture, and they kind of uh, uh, I would say if the valuations are not correct, or if there is certain issues with the valuation, so they contribute in that sense. So it's just not, as I said, that it's not a technical exercise only. It helps in taking commercial decisions, and also for a legal, because say for example, if the valuations are not right, and if a plan is approved or something like that, uh, and it goes to the court, anybody can raise questions, and even it will be difficult for benches also to take decisions on the plans. So it lays a foundation for any company which goes into the CIRP. Then there are, again, as I said, that I am talking about from the purpose of the insolvency itself. So there are three types of valuations. And for that, as I mentioned, that there are now international valuation standards, and they have been adopted by India also, and IBBI also has taken cognizance of those standards, and they have sort of implemented those in their own regulations for valuations. So there are three class of valuations, assets which are valued into the process. One is the land and building. Everybody knows that these are the tangible assets of any company. What is the scope of these assets? Like any land which is freehold or leasehold, or and commercial hai ki industrial, it is whether industrial or residential buildings. And then in the case of real estate, whether it is under construction, or it is kind of completed structure, or there is a sold inventory, there is an unsold inventory. So this is all is in the land and building valuations. There are methods for doing these valuations, which is like sales comparison. So there is a circle rate. So what is a circle rate? Circle rate is generally the rate decided by the government for any piece of land. So this is generally, like, in very layman's language, that's the circle rate. Then income approach, DCF for leased property. Say for example, discounting cash flows is one another method which is also used for land and building uh, valuations. Then depreciated replacement cost. I'm sure you all must be knowing more than me about these methods. Then what are the critical requirements? That a physical site inspection is mandatory now. So although I believe that if you don't see anything, you cannot value it, because just by the papers, you cannot value anything unless you see by your own eyes. It is very, very, and now it is sort of mandatory also that you do a physical verification, like any person who's doing the valuation, especially in case of obviously tangible assets. So any tangible asset cannot be valued unless you see it physically, like what situation it has, because papers may not present the whole truth. So and RERA data and encumbrances. So for valuations, not only physical verification is very important for land and building, there are a lot of other authorities which sort of take care of the I would say verifications or certifications, or say for example, RERA is very one important aspect. RERA is, I'm sure you know that this is the real estate regulatory authority. Every state has a RERA authority. So it has a lot of documents about the land and building, and encumbrances also. So because it is possible that sometimes the corporate data itself would not give tell you all the encumbrances if any property has. So it is very important for the valuer also to bring that out and find out that if there is anything which is hidden in terms of the paperwork of any property. Then there is plant and machinery. This is the second category of valuations, which is the plant of machinery. For any manufacturing unit or for any office or for any building, also there can be a lot of stuff which is, in fact, say for example, for a service industry, it can be computers, it can be laptops, it can be other electronic equipments. So everything, and then vehicles, if it is any kind of company which is using vehicles, for transport companies, say for example, it is a lot of vehicles which has to be. So this is for all those. Again, this is again tangible assets. Plant and machinery is also tangible assets, but they are other than the land and building. So anything other than land and building is does come in the plant and machinery category. And again, for these also there are different methods to assess, like what is the valuation. Of course, the depreciation aspect of all the equipments or machinery or electronics has to be there. Then their usability, if like whether they are usable or not, because sometimes they are so obsolete, the technology is so obsolete that it does not, would not have any purpose. And then of course, like what income it can generate, what kind of production, if there is any machine is there, what kind of production it can do, things like that. So valuation is just not simple. Like it cannot be done in silos, I would say. You have to see a 360-degree view of your assets, like what they are useful for, basically their usability, their sellability, their life, and things like that. And again, as I said, that critical for critical analysis, you need to have a physical verification, because it is possible that by the balance sheet or other papers, you will not be able to assess like what exactly the asset looks like. And of course, the aging, and I talk about the if the machinery is obsolete or the technology is obsolete, which does not is or did not get used now. So that's another aspect. Then third aspect of valuation, or third category of valuation, is securities, financial assets, and others. So securities, like anything which a company has, say for example, any investments or any equities it holds, and any it has investment in any bonds or treasuries or mutual funds, and any trade receivables of the company, anything it lent to any other company. So we will see that in the insolvency, uh, in almost every case, there are some subsidiary companies where the fund goes, where the money has been lent. And then there are intangible aspects also, which are like about the brands, the IPs a company can have, the trademarks, the goodwill, uh, or any other things. So all this collectively will come under this category of valuations. Now, I would say that for again, certain part of these valuations is also, available on documents or on papers. Say for example, any investment or any loan granted or any trade receivables. Although, like, I am not right now getting into whether those trade receivables are actually can be received, or they are just, not receivable at all. So we have a term for this, NRRA, also, like non realizable assets. So there are different things. Still, as I said, that certain part of it is still accessible from papers or documents or some kind of scrutiny. But a lot of part in this category of valuation is something which is not tangible, which is intangible. So brand value. It's very tricky, because any company who has or which has been in business for, say, for example, multiple decades, should have ideally some brand value. But when it goes into insolvency, there is a stigma. We still have in Indian, I would say, economy or capital market, that it loses its brand value. So how do you then assess the exact valuation of that brand? So and then IPs and any soft asset which this company has should have some value, will have some value, but it's very critical, or I would say it's very tricky or difficult part for a valuer to assess that valuation. So, what methods again can be deployed for assessing this valuation is again a very, so it can be very subjective at times, but how you can bring as much as objectivity in the profession, like in the assessment of the valuation, would depend on person to person, like what all activities he's doing or she's doing for assessing these valuations. So again, like you can do certain things, you can fetch out for some information on today, now it's the AI age, where a lot of things are available. But of course, for using AI also, you need your own assessment and analysis of things, and unless you have some basic idea of things, you cannot simply trust the AI, because AI is just a machine, and it provides data, or it provides anything to your question depending on what it has stored in its algorithm. So it's very difficult, of course, but you need to have your own assessment or understanding for using that also. So a lot of information, yes, definitely comes, but depending on like how you use that information. So that's about it. Then the second aspect is regulation. Like, what is the regulatory framework uh, for valuers to be appointed in the process? So the appointment comes from the regulation 27 of the code, which is like RP must appoint two registered valuation within 7 days of appointment, and no later than the 47th day from the insolvency commencement date. So again, I would like to talk about here some issues with the appointment itself. So what happens, we have to do, as I said, that there are three categories of valuations. So we have to appoint two sets of valuers in all three categories. And for these two categories to be appointed, obviously, an RP has to invite at least, say in our case, we at least invite 7 to 8 quotations. And then all these people has to mandatorily now do a presentation in front of the COC for valuation, like for like what approach they will be doing, what cost they will be asking for, what is their preliminary assessment of the corporate data, and things like that. So you can understand, like, if everybody is doing not more just 15 to 20 minutes presentation, it will be like 7 8 sets of valuers into three. So about like 20 22 presentations you will have to get it done, and in that much of stretch. Now it's a mandatory requirement, you have to do it, and it takes time, and sometimes it creates, and COC in many cases, like, they are not very, I would say, either equipped to do the selection, or sometimes like they are just not very, keen to do it. So both things obviously creates a limitation for RPs too. And the another aspect of it is like, if there is a change of IRP to RP or RP to RP, and there are, say for example, in one of my cases, it took me about, because when I came as RP in the corporate data, the data was already confiscated by the economics offense wing, which is the, if you
यस सर, मैम का हो गया ना। एक मिनट, मैं मैम को कॉल करती हूँ।
I think I got disconnected.
हाँ मैम।
Yeah.
आई गेस in your network now there is some interruption.
Okay. So I'll have to share the PPT
Yeah,
again,
ma'am.
right?
Ma'am, yes, ma'am.
Yeah. Yeah.
Ma'am, now you
So
are in network
wait,
zone, no?
I was sorry,
You are in network zone, no, ma'am, now?
I'm not getting you, please.
Are you in network zone, no, ma'am, now?
Am I audible now?
Yeah, you are audible. Continue, ma'am.
Okay. And my PPT is also um just a sec. Getting this.
Ma'am, your PPT is visible.
Is my PPT is visible?
Yes, ma'am, yes.
Okay. So yeah. So I was talking about like there are issues in like how we would be doing this in 47 days. So sometimes when the corporate data is running, there is data available. You can simply do it and take obviously you get the approval from the COC members and then you can appoint. But in many cases, you do not get the readily available information, and you have to go to the as I was talking about in one of my cases, the whole data was with EOW, and it took me about 3 to 4 months to take the data from them because it's in a department, governmental department, and they have a lot of protocols and they need a lot of information. They need a lot of surety, like if I'm the right person who's asking for the information and things like that. And it took me some time. So it's very tricky. Again, it's very difficult sometimes to stick to the timelines, but obviously we try as much as possible to stick to the timelines. And if we are not able to do something in the time frame, then we have to have recorded reasons like why we are not able to do it. Then regulation 35 says that there has to be assessment of two types of valuations, which is like fair value and liquidation value. Fair value is generally, I'm sure you would understand that if a company is running and it has been sold as a going concern, and when the company is still doing business, it still has revenues and things like that. So then what value the company can fetch. And the liquidation value is something where the company is almost at the verge of closure, in the sense it cannot be, the business is not running much, and the assets are only sold, and those assets can be sold into different pieces like land and building, plant and machinery separately. So in different categories it can be sold separately. So that is generally the liquidation value, when the only asset. So what difference, if I would talk about as an insolvency professional, in my own head, what is fair value and what is liquidation value? So in my head, fair value is something which is just not only of the tangible assets, but it also has some legacy value or the brand value or the intangible value which a company brings on the table. So because any company which has been sold, say for example, or we are assessing as a valuer, is just not, it's just not, a work of a day or a month or a year. It is running company for, say for example, for some years or maybe decades, or it can be a century or anything like that. So fair value has valuation of physical assets or tangible assets plus intangible assets plus some legacy value. So that's what in my head is the fair valuation. And if I talk about the liquidation value, then obviously the intangible part or the legacy part gets wiped off if a company is not working now, or is not able to produce, or it's not able to have some revenues. Then only the assets, which can be mostly the tangible assets, but sometimes like some kind of IP trademark or some brand valuation can also fetch some, and it has fetched in my experience, in my past, people have given value to certain brands also, like they have just bought the name and nothing else, so it can fetch value. So I'm not saying that in liquidation there is no value, that it all depends on if it can actually be used in future for any purposes, then it definitely can have. But in general terms, the liquidation value is about only the physical or tangible things of the company which has been sold. So that's the difference in my head for fair value and liquidation value. Then the third pass is adherence. So all these now, as per the international, I would say, standards, all these valuations has to be. So I'm sure you must be knowing now, if you have to share anywhere the valuation, say for example, I have done this in my own. So I am, part of certain networks, or if you are, applying for something which is bigger, you have to prove like you have some valuation, like even if you are talking about your own net worth valuation or something like that. So for that, now you have to send a internationally accepted valuation methods also, and not only just physical valuation certificate, it has to be done online. So that the person who's getting the valuation is sure enough that the valuation is not tempered or anything like that. So it's a real valuation which is done by the valuer. And say for example, we do UDINs, right? For anything, any certifications, chartered accountants do it, right? So something like that for valuations also. That's the now norm coming up, that you will be sending an online valuation certificate, so that this certificate is, truly trusted upon. So these are the regulatory framework for valuations in the IBC. Now the next is, so we had to talk about like what are the issues in having the valuations done under IBC. That's what our topic is. So to start with, first issue which has been seen by most of us is the lack of uniform valuation. As I said, although the government and the regulatory bodies are working on it and they have adopted certain international standards also, but still there is a lot of scope for subjectivity in valuation. So that is why they lack valuation standards, like uniform valuation standards, because if you are changing your, I would say, assumptions, if you're changing your methodology for doing the evaluation, then the results may be different. So, first thing was like historical gap that IBBI did not have. So, after IBC, a lot of standardization has happened in valuations, and now with the international standards, of course. Uh, so what we can see is like as I told you, like in the April 1st, 2026, mandatory IBS compliances for all IBC valuations has been notified and they are effective now. And IBBI now mandates a defined scope of work, methodology, rationale, and it is generally said that say for example, if we are appointing two sets of valuers, so each class of valuers should adopt the same methodology so that it is apple to apple comparison, and it's not apple to mango comparison. So generally, and that then you can see like if the valuations differ or not, and if there is any deviation from each other. So that's how it works. And that's the dual approach conflict, like CIP internationally accepted, vague and open to interpretation, liquidation companies separate methodology. So as I said, that there are certain standard issues which create problems for us in terms of doing not only for RPs, more for valuers. This is more for valuers, that they have to take care of all these things. Then issue second is non-standardized reporting formats. So a lot of times, even the reporting formats are not same. So IBBI is working on this also. Like they are now coming up with these all the three classes different like set reporting formats as well. So if you are reporting your like if you're creating your report of valuation differently, then it may have a different effect on valuations. So now the work is being proposed for this, but initially, like for a very long time, there was no standard reporting method. So and like it also depends like from where you are fetching the data, different public platforms or otherwise, and sometimes everything is not available in public platforms, and people like if they can get some information otherwise as well. So things like that. So now a lot of standardization is happening, but again there is a lot of work to be done even now. Then uh there is a rule which is like 25% rule. So as I said that in IBC there are two sets of valuations are done, and if there is a difference more than or equal to 25%, then there is a third valuation uh, are to be done. Now, this is another a big problem in the sense, and this has happened in one of our cases. So CMI Limited, which is one of the cases which my IPE, matlab, in the sense like one of other partner of the IPE which I'm associated with, was the RP in this case, and we got done two sets of valuations. And then what happened that in these two set of valuations there was a difference of more than 25%. Now we had third valuation, and then third valuation was another case only. So there was no, kind of, uh, there was no s- uh, uh, so similarity is something, I would not like to say the word, because we are not looking for similar valuations, but the valuation reports or the result of those valuations were so divergent that it was very difficult for COC members also and for RP also to understand like what exactly is the valuation. And sometimes what happens in so in each total valuation there were three valuations, and sometimes what happens, one valuation is certain. Say I'll give you an example. So land and building valuation, one valuer assessed it, say for example, for 50 crores. Another valuer assessed it for 40 crores. Then for SFA valuers or plant and machinery, one a valuer valued it at 80 crores. Another valued it at 60 crores. So there was so much divergence into different sets of valuations, and the results were very different or surprising, I would say, from each other. So it was very difficult for us to, and then it actually went to courts also, because we were not able to, kind of justify with the valuations and things like that. So it took a lot of time also. It got stretched because if there is no valuation, particularly, then it is very difficult to assess the resolution plan for COC members, as I said in my earlier slides. It becomes difficult if there are problems in the valuations. And there was another case which was Ransaria Polypack Private Limited, where NCLAT held that where the initial two estimates diverged by only 4%, a third valuation was superfluous. So obviously, if there was not much difference in the valuations, then there is no point in getting done, because as I said, that there's a lot of scope of subjectivity. So 4.5% of difference or 10% difference can be because of the subjectively using the data. So now it has been reinforced that unless there is a more than 25% difference in the two valuations, the third valuation cannot be done. But obviously, it also depends, like it's COC's commercial wisdom. If they want to get it done, if they are not satisfied with the valuations, they can obviously get it done again. So that's the regulatory thing. Now, fourth issue is assessment. As I said already, intangible assets valuation is the catch. It's very difficult, and sometimes it is possible that the company actually does not have many physical assets, and the major value lies in the intangible assets only. Say, for example, so one another case which we are doing right now as part of the IPE is the I'm sure everybody would have heard about the Mother Pride schools, Mother Pride and the Presidium schools. So there are these three companies which are under insolvency, and we as IP is supporting the RB for these cases. Now, the biggest question or biggest problem in this case is actually multifold. So one, that the largest asset of these companies are the two brands, which are Mother's Pride and the Presidium. And they do not have a direct, obviously, like the TRA and other things, or the fraudulent activities are separate part. We are taking care of that. Uh, but on the face of it, uh, they do not have any school under the name of these three companies which are in the insolvency. And in most of the cases, they have some franchisee agreement with all these schools who are using these brands. And now the fight is that the brand is the company's asset, but if there is no school running in the and when there was obviously the insolvency starts of any company, so the takers will come to you. I am talking about the like reality of the ecosystem. The takers will come to you, like whoever you owes anything to, they will come and ask you to give them back. But givers, like whosoever you have to take, say for example, the corporate debtors, your corporate debtors and receivables, and anybody who owes money to you, say for example, the franchisee owners, or the companies, the schools which are running and has any franchisee agreement with these companies, they will not come on their own. So you have to really dig in. You have to go behind them. You have to make them pay you, in the sense like when you see your papers and you do your research work and you see that, yeah, these schools are running and they're using. So in this particular case, like for us, it's sort lot of litigations part, because nobody's giving us the rights or the remuneration for using our brands. And even the promoters or the company's owner, the erstwhile owners, also claim that these brands are not part of these companies, or they have already kind of siphoned off the brands also from these companies. So anyways, that's a litigation battle we are doing, and almost like all the courts, high court to NCLT to NCLAT and everything. But again, for this kind of situation, assessing the right valuation, and only, I would say here that only the valuer in in separation cannot do the valuation of these kind of assets, because the valuer would need continuous support from the RP, from different authorities, from the whole like gamut of people which are into the or involved into the process. So for this purpose, I would say creditors like financial creditors or other creditors will also play a vital role in getting the valuations reached, because otherwise the whole information will not be available with the valuers, and they will not be able to do justice to the valuations. And in this case, as I said, the maximum value lies in the soft assets only, in the intangible assets only. Then it becomes even more and more difficult. Then, as I said, that the going concern or the intellectual property or the customer relationship. So if you have, say for example, if you are a service company, and you have a list of 1,000 clients, and with those 1,000 clients, anybody who say for example takes over you as or buys you out, what value the buyer is fetching from this client list is also. So this is how in the real world, valuations are reached at when the negotiations happen for any company for valuations. This is how it works. So but then valuers also have to take care, or I would say consider the network, the client list, the presence in the market, and things like that. So or any long-term contracts the company has, which say for example in the but now I think the law has been otherwise, like say for example for any airways company, the slots are an asset. For any telephonic like telecommunication company, the licenses are an asset. So depending on, see what is the statutory standing of these, because sometimes now, like for a reason I understand that the try says that the licenses are not part of the asset of the company. Say for example for airways also, the GCA says that the slots are not part of the assets of the company. So a lot of debate is going on that front as of now. But in my view, like obviously anything which creates value for the company should be part of the valuation, in nutshell I can say. So these are again issues to estimate the value of the corporate debtor, and these are real issues. Like these are just not on paper issues, and we have dealt with all kind of these issues in practical. Then practical data and access challenge. So as I said that in most of the cases, if the corporate data or the is sort of non-existent only, then you don't have any data available with you. Uh, then how would you provide the data to valuers to have the assessment? So sometimes the papers are not available. Then in that case, first it's RP's work to collect these information or data or whatever documents they can, kind of fetch from wherever. And then obviously it lies on the valuers also. It's valuers prerogative also. If they have taken an assignment for valuations, they also dig in as much as information they can get to do the valuations. So but obviously but if not much data is available, then it's very difficult to do the valuations done. Again, for physical assets, you can still do physical verification and reach out to certain valuation. But for soft parts, for SFA part, it's very difficult without the data. So again, that's another challenge where you do not get enough information about the company. The valuations are a very tricky situation. Like valuations are very difficult to be to be done. Then obviously, as I said, that reliance on reasonable assumptions. Valuers must work with incomplete data and apply professional judgment. All assumptions must be explicitly disclosed and justified within the report. So as I said that if you are using your assessment or your own thought process for doing the valuation in absence of the uh, exact documents or in absence of any exact information available with you, then it should be, kind of clearly stated, like whatever valuation one is doing, why he's doing it, like what is the thought process behind it. So you need to disclose every possible information or your thought process or assumptions, like on which you are doing the valuation. So that's another. So then again, in this case, a lot of subjectivity can happen, but it can be mitigated with the application of mind, of course. So that's another issue which we see day to day in reaching the valuations. Then I have already, although stated that the physical verification not only is mandatory, obviously it's prudent also to do the physical verification, and otherwise you will not be able to do the real valuations. But sometimes there are restrictions. Say, for example, it is possible, and it has happened with me as RP, like initially, that the workers were not allowing me to go inside the company premises, like the factory premises. So if I am not getting in, obviously they will not allow the valuers also. So a lot of, communication happened, a lot of talks happens after a lot of understanding and taking them uh, into this understanding that the company has gone into insolvency, and we have come here to revive it and things like that. So a lot of I would say to and fro information and a trust level where they can trust that yes, you are the right person, you have come for the right reason and things like that, and then it happens. But yes, for sure. And there are sometimes like so one account we were doing in the power sector. It was a thermal power plant, which was like very, very, I would say, uh, secluded part of the southern India. So, reaching there was also like you have to take 2, 3 flights first, and then you go by the taxi to, or you will not find, readily available food there or anything to stay there or things like that. So then it becomes very, very challenging to do the physical verification of the assets. But again, as I said, and it entails a lot of cost also, it increases the cost also getting the valuation done. But any which ways, for RPs also and for valuers also, for purpose of doing the valuation, it's a mandatory requirement that you have to do the physical verification. We in any case have to take the asset under our custody. We have to go and check the asset, like, because what happen if we will not do it, later on it may come on us that something is being, kind of put on us, that the asset was there and we have done something with the asset. So obviously it's very, very important that we take the custody and control and do the whole paperwork to show like what all we have taken in possession. And exactly we would need that to give to the valuers also, like these are the assets which we have, and you have to assess these assets, or you have to bring out the valuation of those assets. So sometimes, as I said, that it is limited, or it becomes difficult to do the physical verification. And challenges, photographs and sampling protocols must be documented. And as I said, that we in any case prudently do it, that we click the photographs, we make the videos of all the assets when we take. So same is for the valuers also, when they are doing or going for the valuations, they should also do it, so that later on they can, kind of explain like on what basis they have done the valuations. So it's very, very important. Then again, non-verifiable assets, as we have been talking about, that any asset which is not in black and white or not physically available, then how do you value those assets? So then you cannot do any physical verification, and then again you will base your valuation on certain assumptions, and you will use some methodology to reach to the valuation. But yes, it is a difficult thing to be done. Then valuations of debtors and receivables. So as I talked about already earlier, that there is a lot of part of valuation of any company lies into the soft assets, and we can actually not say them the soft assets also, because they are very much in the pen and paper. But all those corporate debtors whom you have to take money from may not come out very, very uh, prudently, or very in a very acceptable way, but you have to make them. So what is required here, that obviously first will be the RP's work to get these things, find out from the balance sheets, from other data information available with the company, or otherwise from any other sources, if you can find out, and then properly document it and give it to the valuers so that they can assess, like. And from the valuers angle, it will be another, I would say, one more step to be done, is this, that whether these so it may show in the books, or it may show in the um, balance confirmations and things like that, but whether you will, so I'm not saying that you will have to go and do the valuation of those companies also, from where you have to take money, and whether they are in ability to pay you back or not. But at least some assessments they will have to do, whether this money is coming or not. So we all know that as an entrepreneur, or as we are running companies, or we are doing businesses, we always have to keep seeing, like, what money we are. So I'm sure, like, bankers also do that all the time. Like, we have to sort of write off certain assets, or certain entries from the books, for the purpose of, so that if you keep, say for example, if any debtor in my organization, we do it, if any debtor which is like 3 years or more old, and like enough after enough, I would say, follow-ups, he's not paying and things like that. So we also put it into a certain category of assets, and we now see that maybe this is a dead money, and it is not coming back to the company. So certain assessment of these kind of assets also, like, valuers has to see whether this money is coming or not coming. So on that basis, they can kind of do the valuations. As I said, that debtors' financial capacity and credit worthiness. So I'm not saying that you value the whole company, but at least from some public documents, or some assessment of that company, definitely, like, valuers should undertake to do the valuation. Then fair value benchmark. Market benchmarks for fair value may exist in some sectors, and in some sectors they don't. And in that case, like, pure transactions analysis and sector recovery rates can be applied. So again, for example, we all know that in practically, when businesses are valued, we always keep listening, like, 1 billion, 2 billion, $5 billion valuation. So how these valuations are reached at? So not only just the company's own, I would say, balance sheet plays a role into it. Say for example, now any IT company or AI company will have valuations much more than any manufacturing unit per se, or any technology which is now, say for example, obsolete. So I will give you an example of my one of the cases. Like, again, as IPE, we did that was a solar power company. And if you will go to the plant, I think it will be coming in the another slides also. I have given the example. So if you will go to the plant, so they had two sites. One where this whole solar panels were installed, and the electricity was produced, and the other was the factory where these solar panels were made. Now, what happened? This solar company was not very old, 7-year old only when it came into insolvency. And actually, in India, it was a very good company. It was state of the art manufacturing unit. But what happened? Why this company went into insolvency overnight? So this was a German technology, or I'm just, kind of using it for the purpose of explanation. So it was a German technology plant. And what happened? A Chinese company came out with another type of flakes which are used for solar electricity production. So they came out with another type of machinery which was creating these solar panels which are lighter, thinner, and produces more energy than this earlier existing plant. So overnight, sort of, this company became became sick in the sense because now this technology, even though this plant was very good, the plant and machinery, the plant and building, everything was like intact and very good, but because some technology came which was, I would say, cheaper and had better productivity, so it became sort of um, obsolete. So it wasn't obsolete, but obviously the market for future, uh, it got kind of limited. So that is why this company went into insolvency. So now assessment of these market conditions, like how any asset will be valued, will also have to take into consideration, because even though the physical asset is very good, even though the life of the machinery is very good, even though everything else is like good, but if it cannot have future revenues the way it should have before this another technology come, you cannot value it the same. So obviously, maybe the physical or tangible assets you may value for the land and building and everything, but for the technology, you cannot have the same value because now something cheaper or better is available in the market. So it is, now it's a related value. So the valuation will change for this particular asset. Then obviously liquidation value is always challenging because it's very difficult to have fair. I would say fair value is still easier than the liquidation value, because in the liquidation value, one, that the asset value is maybe deteriorated, and two, that what will you provide for the intangible assets is very, very subjective, and it's very, very difficult to assess. Because if the company is any which ways is going into liquidation, it's very difficult, like what it will fetch. And they are again very, very unpredictable. So sometimes the liquidation value is very high, but it fetches, say, for example, in the bids, low value, but sometimes the liquidation value is very low, but it fetches a very high valuation when the bid is happening. So again, it's very, very, so I will be coming to like what could be the reasons of these differences in the valuations, but it happens like very much. Standard approach for this particular purpose is that obtain balance confirmation in age of the debtors. So, as I said, for the assessment of the books, then step to assess legal enforceability and counterparty risk. So, if there is any counterparty risk, or say, for example, if your claim is towards any government authorities, so there are, awards which you will have, but then the government will again kind of have the counter this thing. They will file for um, some, they will means challenge the award and then things like that, and then this happens like multiple times, and then what is the exact so again, we have done one EPC company as process advising, and the whole asset was into the government awards only, like 22,000 crore debt, but most of the valuation or most of the asset is the soft asset, like the recoveries from the government department. So how much recovery it would happen eventually is a very big question. So valuation is also a very big question, like how and what valuation it would fetch. Then apply prudent sector benchmark discounts to arrive at liquidation value. As I said, that you will have to see the whole ecosystem, the market, the industry, everything, and accordingly you will have to apply the valuation. Then governance and independence of registered valuers. So for any professional, this question always comes, like how independent you are doing your work. So integrity aspect of any professional. So I'm sure you must have heard that for RPs, there's a lot of I would say a lot of buzz around like how RPs are not doing their duties very, very diligently and things like that. So it happens because, see, wherever there is human element, any profession, so wherever there is a human element, a person, so if it is not a machinery, which will give even machineries do mess up sometimes, but 99% we can say that the machineries do the right thing. So as long as like 1 plus 1 is 2 thing kind of thing, it's easy to kind of. But wherever there is a subjectivity element, wherever there is a human element, there is always a risk of having any loss of independence, integrity issues, sincerity issues, obviously. So, as I said, that it is very important for valuers also to take care that whatever they are reporting the valuation as, they should have proper explanation of assumptions, proper reasons why what they are doing. So things like that. So you can only, as humans, mitigate most of the risk, but you cannot devoid of all the risk. Or you can never do that. So this will always be there. But to curtail or to keep the integrity and independence of the valuers, so certain regulations are there from the governance point of view, that one, that the valuer should not be a relative of the resolution professional. So there is no related party or conflict of interest sort of situation. So the governance is there for that the one, that it should not be a related party or relative or auditor of the corporate data. So, a lot of chartered accountant firms or audit firms do the valuations also, especially the SFA valuations are done by the chartered accountants only. So if that particular chartered accountant or the firm is the auditor of, in whichever capacity you are of in the last 5 preceding years, because then it is possible that you may manipulate the valuation. So this is the government's criteria, that you should not be the valuer of in these cases, like if you fall in any of these categories. And non-negotiable independence is uh, any perceived conflict of interest can delegitimize a valuation report. So obviously, as I said, that if it has been established that you are a related party or a relative or an auditor or in any of these capacity, then the valuations cannot be trusted upon. Uh, but of course, conflicts must be disclosed proactively after appointment is accepted. So in any which ways, as RPs, we have to disclose it on the IBBI website, that these are the professionals we are appointing. So any professional we appoint, whether it is valuer, auditor, or transaction record analysis के लिए whatever auditors we appoint, or any other professional we are appointing, we have to disclose it. So and we have to disclose the relationship if it is there in their pre-existing relationship. So any which ways, we cannot appoint any valuer who's like having a conflict of interest. And then judicial standards, are courts now treat valuation as a, so now, so much so that, as I said, that the valuations are important, that they have been now taken as a quasi judicial process, like it is a judicial exercise which valuers are doing now, and it is very, very critical and important. and valuers are expected to demonstrate independence, diligence, and transparency. So there is a whole lot of code of conduct for valuers also, like insolvency professionals, and they have to have, the outcomes of any proceedings if happens, like they have to look into that. So that's another thing. Then confidentiality of valuation reports. So valuations, although are sort of, you know, s- so here I would say that if you are growing, if you're doing good, then you would like the world to know, like, how much are you valued. But especially when the downfall starts, or there is an insolvency or bankruptcy triggers, or sorry, liquidation triggers, then the valuations can be, if shown outside, detrimental to the perceived value of the corporate debtor. So when and to whom these valuations can be disclosed or shown is also a big, I would say, question. And the consequence of leakage, because if the valuation gets into the wrong hands, or if, say, for example, and this has happened with us again, uh, in one of the company, the valuation was much less, but the plans which came were of a higher values, because of the reason that the demand for the product of that company, particular company, was very, very high because of the government procedures. So government had notified certain changes, and for the growth purpose. So it was, say, for example, it was a contributing company into the infrastructure of railways, and government had come out with certain, thousands of kilometers of new railway tracks to be built, and this was one of the ancillary company which was providing something in the railway industry. So all of a sudden, what happened was, the valuations for any asset related to those industry went up significantly. Although this particular company was under insolvency, but the resolution plans for this company which were coming was actually double the fair value or liquidation value. So you can imagine, if these valuations get into the hands of these resolution applicants, obviously it will be detrimental for the realization, or for the value maximization of the corporate debtor. So, but then, as per the law, we have to give it to the COC members after taking the, of course, NDA or the non-disclosure agreement signed with them. And it is sometimes possible that even if the insolvency professional or the liquidator has not disclosed these valuations to anyone, but any other member who was entitled to take these valuations have actually taken and disclosed this to somebody who is misusing that valuation information. So keeping the valuations in confidentiality is also one of the tasks with us as insolvency professionals. So, as I said, that I'm talking everything about the issues or challenges in the IBC, and this is actually a real challenge with us. As RPs, we face it. Sometimes it happens that if the valuation is being known to the resolution applicants, then of course the maximization of the asset is detrimental. So we have to be very careful, and we try to do like whatever possible in our scope. And sometimes it is possible that if the valuation is disclosed, and even the you can fetch or attract some litigations because of that. So a lot of litigations are actually happened because of the matter of valuation. So these kind of issues, which again are sort of barriers, and we need to maintain that the valuers also and it also depend a lot of integrity of the valuers also, because they also should not, kind of go and disclose the valuation to anyone. So yeah, that's the issue. Then, as I said, that judicial scrutiny and litigation risk is always there. So anything and everything, any professional works, because there's a humanity angle, because there is a integrity issue, because there is a subjectivity angle, we are, always can be challenged. So anybody can challenge the work, or the assessment, or the methodology, or anything. So uh, valuations are also prone to that, of course, and it is a vulnerable lot. So anything, if you are doing not diligently, you're just copy pasting certain aspects of it, or if you're not justifying like how and why for any number you have put in, and if you're not using the available data correctly, say for example circle rate. So as I said, then even circle rate is not the right benchmark for the land valuations, because sometimes the actual valuation can be less of the circle rate, and sometimes it can be much more than the circle rate. So I think valuers should always keep in mind the sellability value of the asset. So if any land in question is to be valued, then it should not be only circle rate, or it cannot only be the market rate also. It has to be certain some sellability aspect of the land, like at what price it can be sold, or at what price a market is available for that particular land, or a buyer is available for that particular asset. So that's what the evaluation is, kind of akin to. And fresh valuation grounds are permitted only for material so if you are changing in between, say for example, any assumption or anything, so for that also you should have certain reasons to disclose that why, if at all, you are changing that. Then litigation risk mitigants is comprehensive working papers and documentation trail, peer review of methodology, and explicitly sensitivity analysis and scenario testing. So all these things can mitigate the litigation aspect related to the valuations, but still, if one has to do it, they will do it anyways, because we keep seeing in our experience many frivolous applications which keep getting filed to the NCLTs and NCLATs, even the frivolous appeals also, depending on any aspect. And people are different, they think differently, they behave differently. So you cannot, kind of do anything about it. But yes, as a valuer or as an insolvency professionals, we people, what we can do is like best documentation or best communication, what we are keeping is something which is important. So this is what is like a valuation that cannot be explained, cannot be defended. So if you cannot explain what you have written, that why you have written, or on what basis you have reached the number, if you cannot explain that, uh, your valuation is not right, of course. So then it is a hypothetical valuation. Then vague methodology and mandatory COC presentation of valuation reports. So sometimes if you have not chosen the right method of valuation, and if you have done some arbitrary sort of numbers, then obviously it will be challenged. And what you can do is to mitigate it, that you should not be doing it, or any valuer should not be doing it. And COC, as I said, that even now before choosing the valuer, COC takes the presentation, like they do meet all the valuers proposed, and they understand like what kind of methodology they will be deploying for reaching any class of the valuations or any class of the assets. And later on, also after the reports came, they have to do the presentation. So means the valuers should be ready to do the presentation, like to wherever, however they have done the valuation, why and how they have done this valuation, and what is their assessment of the assets. So uh, again, a valuer who cannot, because ultimately COC in its commercial wisdom is the final uh, person who will accept the valuations and who will actually use the valuations for assessment of the resolution plans, or for choosing the like buyer for the company. So it is again very important that the COC also takes the active participation in the COC when COC meetings, when these valuations are discussed. And obviously valuers are also, mindful that they will be presenting it, and before closing the report or the draft report, making it a report, they need to explain everything, like why and how they have done it. And legal basis, of course, now there are standards for valuations and they have to take care of it. As I was talking about, like VRIN number is now mandatory identification for registered valuers, and you will be providing your valuations under your registration certificate. And for the valuations also, like they will be online available and can be seen. So that's how. So what is VIRN? Is valuer registration and identification number, and you have to be attached with a registered valuer, which of course ICAI also have. And you can have like into three categories. You can have in one category, two category, depending on like what is your skill set and what is your qualification, and you have to pass an exam for doing that, and then you can get registered yourself. And then there is a RVO sort of registered valuers organization. Yeah, RVO concept is also there, where they have all kinds of valuers, like all kinds of valuers in different categories registered with them, and they form a organization, and then they can provide a consolidated report of valuations of all the three categories. So this is how it is generally done. And then regulatory mandate is that the companies, registered valuers and valuations rules and IBA, that the cover page of every report, all interim communications, the COC presentation, all these has to be done, and the report should be one consolidated report. So earlier it was like we were doing in between actually. The practice was that we had to get the three valuations differently and we had to present. Now a one consolidated again presentation can be done, and obviously all the three valuers will be named in that presentation who has done, but one of those can be the leader of the group of valuers, to simplify. Yeah. And VRIN creates an auditable trail linking every valuation output to a specific licensed professional who can be held accountable by IBBI's disciplinary mechanism. So there is a disciplinary mechanism for valuers also, which IBBI undertakes. And if there is any complaint or there is any issue in the valuation, they question it also. Valuers who operate within a valid VIN or whose VIN reflects a lapsed registration face criminal liability under the Companies Act and IBBI enforcement action. So, if you are not an eligible valuer to value any asset, then definitely you may face some criminal challenges also. Then asset light companies and brand valuation, the emerging factors. So as I said, that there are multiple companies where they may not have physical assets or very prominent physical assets, but they do have a lot of value in the companies. And why this matters for CIRP? Because undervaluing brand equity in a CIRP can result in the resolution plan being accepted at a lower price. As I said, for Mother's Pride and Presidium schools, they may not have much physical asset, but their brand value is huge. Is huge. Hundreds of schools are running under this brand, and they have a good market reputation. And we have to be very mindful also, for one thing, as resolution professionals and as valuers, that any activity of ours should not be reducing the value in the sense. So whatever actions we take in these companies, Mother's Pride and Presidium, we are very mindful of that people or the users of these schools, like the kids, the parents, should not be affected in any way. And you can imagine, like, if you know that your child is going to a school and that school is under insolvency or the brand name is under insolvency, what impact it may have. So you cannot, publicize a lot of things. And even if a lot of information is available in the public domain areas, you can still not, make it very, I would say, upfront, or how do I say it, like, it's very important to have that trust remain into that brand or into that company, so that it does not disrupt the value of the brand. So it's very difficult. At the same time, it's very important also to keep it intact. Then there is a problem of valuer competency gap. It is possible that the valuer does not have enough skills to value certain aspects of the valuation. For that, like, we really need to, and that is the reason why we are having now presentations in the COC, because otherwise what was happening is, like, if the valuation is not correct, then everything was coming on the RP also. So it is somehow mitigating the RP's risk also, that the COC is now takes the presentation. And if one mind cannot, kind of assess the skill set of another person, a group of people can definitely understand, like, and can analyze that whether the person is good enough for doing the valuation or not. So it is very important that COC does take this very seriously and chooses the right valuer, so that there is no skill gap, basically, or competency gap in the valuer vis-a-vis the asset to be valued. Then there is a brand valuation new requirement under the IBC amendments. Register values handling assets light CIP cases must be equipped to value brand recognition and market position. As I said, that these are intangible things. And for this, a lot of analysis, a lot of research has to be done. And customer loyalty and lifetime value. So again, a lot of data you will have to analyze of the CRM, which is the customer relationship management. And then you have to see, like, how customers view your company, what is the loyalty percentage and things like that. And it will depend on lot many these kind of aspects. Then proprietary technology and data assets. So maybe that the company does not have a very big tangible asset, but it may have, say, for example, we all know that when the corona vaccines came, obviously the IP was with some companies, and they were, having, and recently these obesity drugs, like, for any patent, you can have it for 10 years. So if, like, how many years that patent is still have timeline left, so that the value can be fetched or things like that. So there are so many, practical, or I would say, marketplace informations which you need to have for doing the valuations for the asset light company. and then franchise agreement and licensing. So this is what we are exactly doing in the Mother's Pride and Presidium. Like we are collecting all these franchisee agreements and licensing rights for using our brand name, and we are kind of in which cases we did not get those licenses or agreements. We are now in the process of, means we have done multiple franchisee agreements already with these schools whom we did not find the franchisees agreement available, like readily available. So these are the exercises which as RPs and valuers like we do together. And then obviously when then there are in for franchisee agreement in place, so you need to as a valuer assess like what will be the I would say recoverable value of the company. Then why this matters for CIP? Undervaluing brand equity in a CIP can result in the resolution plan being acceptable at a lower price, which is against the spirit of the law. So the law says that we are here to maximize the value of the assets of the corporate debtor, and that's what we should be endeavoring towards. So now there's another issue, which is like, I think every RP who has done any real estate company would have dealt with. And I, being one of the person who has actually dealt with all sorts of real estate companies, like a real estate company where there was a huge big hotel, and there were buyers also, like the promoter had sold all the units as a serviced apartment, so there were some sold inventories, some, and then there was real estate like commercial residential projects where there are sold inventories, there are unsold inventories, then there are another cases where there were people living already, then there were a certain people who were not living because the possession was not given, and then there was some unconstructed. So real estate is one sort of sector where valuation, although the asset is very, very tangible, it is very, very seen, but at the same time, there are multiple issues which are there for the assessment of the valuation. Say, for example, earlier, the assessment used to happen in terms of the project value. What I mean by the project value is, say, for example, the whole project is of 1,000 crores, and that is why the valuation of the company is 1,000 crores. But you can imagine a new investor who's coming in, who has to construct this project, because this project is obviously not completed, and he has to complete the project, and for which he would like to see like what will be the ROI of his money, in the sense like what ultimately he will be bringing in to complete the project and what he will be getting out or taking out of the corporate debtor. But say, for example, even if the value of the physical asset of the company is 1,000 crores, but the corporate debtor, the erstwhile corporate debtor, has already collected, say, for example, 700 crores and has taken out of the company. So he did not complete the project. And now the unsold inventory is only left for, say, for example, 300 crore for our conversation purposes. So 700 worth crore of the asset has been already sold, and 300 crore inventory is left now. But to complete the project, actually 400 crores are required, because the corporate debtor did not put all the money in the company and he did not complete the project in terms of or in the same ratio he collected the money. So now the project has to be completed in 400 crore and the inventory is only 300 crore. So do you think that the for the loss of 100 crores, any And this I'm talking about the completion. Now, any money, like anybody who's coming for completing the project would also want some profits on that. So say, for example, if I kind of levy 10% profit also. So if I'm putting in 300 crore, or sorry, 400 crores, I would like to take out at least 440 crores out of it. Now, how this will come? And if now the valuer assesses the asset as 1000 crores, it will be a misnomer. It will be a misguiding valuation, because the valuation actually is negative. Actually is negative because to complete the project is required 400, and the only unsold inventory is 300 crores. So what will happen is, in this case, the investor or the uh, or the um, or the developer who's coming in to complete the project will need some extra cash. On who will give this extra cash? Existing buyers. So in many of the cases, you must have heard that there is an escalation cost. What is that escalation cost? Because now this new developer uh, or contractor has to bring in 400 plus crores. And from where this 400 plus crores? So one aspect is that maybe the price for this 300 crore inventory may fetch little more money than 300 crores, because the price of the real estate always, like in the long run, it always goes up. So he may fetch little more money. And two, that you will have to take some money from the existing home buyers. They will have to shell out some escalation cost. So in this particular situation, even though the physical asset is much more value, but the actual value of the asset is in negative. So in this case, the right valuation can only be derived by assimilating all this information, like so in this case, the land and building valuer has to be very, very equipped with like the market value of the asset, then construction cost, which is required to be put in, then obviously the unsold inventory, at what price that unsold inventory can be sold, and if there is any recoverables from the existing buyers. So it is always possible that before the possession, always like there is a clause that some percentage of the money will come once the possession is handed over. So in this condition, like maybe there is some recoverable from the existing home buyers also. So the actual valuation can only be derived by analyzing all these aspects of the real estate valuation. And same goes for the plant and machinery also sometimes, and same goes for the SFA also. But for the real estate, it is like very, very critical that you keep this all these uh, things intact. matlab, take consideration to reach out at the valuation. And map or unsold inventory with the trader project. So these are generally, and the problems is amplified from the very reason that the home buyers are also the financial creditors in the process, and their representative sits in the COC. And anything, if you're not doing rightly, obviously you will have a lot of backlash. So the right, and yeah, another problem is, say for example, from the corporate data books, you see that 700 units are sold, but you have not received claims of all these 700 people. So you don't know, like sometimes, whether these 700 number of sold units is right or not. So that's another kind of question of a lot of debate and things like that. But uh, as RP, and obviously it will be dealt into the transaction record analysis also, or you must be doing some maybe audit of forensic audit done in the process. So many things will come out in that also. But of course, means as a RP of a real estate company, there are always a lot of issues which you have to be very mindful of. Uh, so another sector specific valuation challenge is related to like real estate, we already talked about. Infrastructure, energy related also, as I said, I also talked about that solar company, which, so a lot of thermal power projects, like because they were using a specific type of coal and now that coal is not available, the company, although the plant is good, machinery is good, but their perceived value goes down because now it cannot generate enough revenues to sort of support the valuation. And again, I talked about this pharmaceutical thing also. Drug patents, ANDAs, and technology licenses constitute the primary value drivers. And say, for example, if you, a pharma company which has been now for up for sale or for acquisition, which has uh, say longer period of exclusivity, that they can only produce this particular medicine, then it can fetch much more value. But if the patent is going to expire very soon, then obviously they cannot fetch, because now others people will also, say for example, recently it has happened for the obesity drugs worldwide, where they were having the companies who had brought out these drugs were actually kind of enjoying a lot of exclusivity. And as soon as that patent got expired, like for after 10 years, the drug has to become a generic drug. And then obviously those companies may not fetch that huge valuation which they were deriving out earlier. Then another angle to assessment of valuation can come out from the deferred tax assets. So we generally have written it deferred tax assets, but it can be deferred tax liabilities also. So if any asset which you are going to buy has any deferred, so say for example, in insolvency, sometimes the companies are sold at a higher price, even though there is no revenue coming in, there is no future prospects of much revenue, there is no much physical assets also, but still, because it has a lot of carry forward losses, where which a company can use for for curtailing the taxes or income tax, then the company can fetch better value. And on the other hand, it can be a reverse situation also, that the company has a very good physical asset, land, building, this, that, but it has a lot of deferred tax liabilities also. Say, for example, it has a lot of GST liabilities, it has a lot of TDS liabilities, or any liabilities. So any statutory liabilities it may have, although the physical value of the assets may be higher, but the actual valuation which it can fetch if the company is sold may be lower because of these tax liabilities. So it can be both ways. It can be a asset also, like the contingent asset, or it can be a contingent liability also on the asset. So in that case, we all know that EPFO, in case of EPFOs, because anything which has been secured for paying the PF dues are also not part of the liquidation value. So it's the law. So in that case, if anything which has been kept for the PF payments, by that
Ma'am,
amount, sorry, yeah,
your voice is not audible.
okay, and why
It's
so?
coming perfect, no perfect.
It can be only internet, like sometimes,
Okay, ma'am. Okay, no issue.
yeah, yeah. So in that case also, like the valuation may be impacted. So valuers has to take care of these aspects also, like they need to look into the future um, liabilities or any future gain also while doing the valuation. So that also matters a lot. Then synergies revised definition, IBC amendment explicitly includes underlying synergies within the definition of fair value. So, when valuation is done on a group company level, and if there are any synergies with the sister
Ma'am,
concerns
there
and
is
things.
some network issue.
Okay.
Yeah, your video has been stuck, ma'am.
Okay, so maybe we'll have to wait only because I have no control over my network. So should I switch off the video maybe? Will that?
Yes, ma'am, now it's perfect.
Okay. So it
Yeah.
fluctuates, yeah. Synergies of underlying assets in the sense, like if it is coming with certain subsidiaries, like wholly owned subsidiaries, then what is the synergy it is creating with the main company or main asset? Then also the valuation changes. So that also affects the actual valuation of the company. Then mandatory IBS compliance, I already talked about that. April 1st, 2026, it has been notified that there are certain aspects of it. One is that explicit basis of value. Each report must state whether fair value, liquidation value, or another basis is applied with formal IBS definitions. Then methodology, rational, the valuer must justify the code of or the choice of methodology, income, market, cost approach, whatever approach they are using for each asset class with explicit reasoning. Then define scope of work. You have to always define your scope of work, like what all you are including, the purpose, the subject assets, the intended users, and valuation date must be like as latest as it can be. And then sensitivity analysis, where reports must include scenario modeling like beer, baseball, whatever it is, showing the impact of key assumptions on value. So as I said, that valuation cannot be done in the isolation. It should be always done in the totality, like analyzing every aspect of the company or the market situation. The coordination valuer reform, as I said, that it was initially like this, then later on in the middle, it was like all the three categories of valuers would report separately. And now we are back to the initial thing that these three valuers will do their valuation separately, but there will be a coordinator who will be doing coordination with these three valuers, and then it will be giving an aggregate value of the company. So obviously, sometimes they may have some issues within the classes, but ultimately it has to be done in totality, and average of two closest valuations should be estimated or should be the right value. And try to do like the two sets of valuers for different categories are using the same methodology and same assumptions, so that the valuations are apple to apple, and it's not creating any further confusion in the valuations. Then so there are few landmark judgments related to, as I said, that valuations are, tricky, and it attracts a lot of litigations if not done rightly. And there are multiple Supreme Court, means obviously Supreme Court judgments are the final acceptable jurisprudence. Obviously, if NCLT or NCLAT also does anything, or any other court, that's also something jurisprudence. But something which has been pronounced by Supreme Court is the final, I would say, stamp on that particular issue. So, in the SR Steel, valuation is central to determining the feasibility and viability of a resolution plan. The COC's commercial wisdom, while paramount, must rest on a defensible valuation foundation. So, there were issues in the SR case. The valuations were challenged, and Supreme Court said that if the valuations are done with the clear, I would say, assumptions, and the methodology was right, then definitely the valuations can be taken as a benchmark for assessing the resolution plans. Then Maharashtra Seamless Limited, A resolution plan need not offer a value higher than liquidation value. The commercial wisdom of the COC prevails, but the underlying valuation must itself be defensible and methodology compliant. As I said, that it is possible. Sometimes in some companies, the valuation goes much higher, and sometimes the valuation goes low. If the future predictability of the business of that particular company is, low, so it may fetch a lesser valuation. So valuation for COC's decision is just, kind of directory, not mandatory, but yes, it provides a base for taking the decision. Then rainbow paper register values must correctly identify and factor in all statutory charges, which I already talked about, like the contingent asset or liability, preferential rights and encumbrances when computing both fair value and liquidation value. So it's a very mandatory or very important aspect, that even if the company may not have that particular valuation at present, but what will be the future valuation also, depending on assets or liabilities coming out of any particular activity or contingent future incidents, then those incidences or situations should also be taken consideration into the valuations. The future of IBC valuation lies into maturation, like IBC valuations has been evolved, and a lot of technical aspects are there of the valuations, and a lot of judicial clarifications are also there. But obviously the insolvency ecosystem is also evolving and developing, and so is the valuations. Credibility standards are getting better and better every day, but again, it's a very subjective matter to an extent, and that is why standardizations may not work effectively. But of course, the more standardized processes will ensure better valuations. Then IVS mandate, I have already talked about professional responsibility. So this is like person to person, and it is a personal code of conduct also, like how a professional is conducting itself. And especially valuers who are, doing these valuations should use the right methods and technical competence for doing the assessments, and that's how we can mitigate most of the risks. Now, I always like, this is favorite part of my presentation. So I always say, and I can definitely, kind of conclude it into that way, that as the beauty lies in the eyes of the beholder, valuation lies in the eyes of the buyer. So any asset, as I said, may not have, I would say, tangible or intangible, accessible or non-accessible value, low or high or whatever it is. If there is no buyer of that particular asset, in my views, there is no value. And in my experience of last 10 years being an insolvency professional, I have seen that uh, a company which may not apparently look very valuable, or valuations on paper may not have been very high, but the market situation or the demand for that particular product may fetch a much higher value, which I have already talked about, a scenario where there was this company was the is manufacturing railway wagons, and all of a sudden, when the government notification came and government was proposing thousands of kilometers to be built, of the railway lines built, so obviously to ply rails on those railway tracks, you need wagons, right? And all of a sudden, the value for this particular company actually gone up very high during the process. And though the valuation done for these companies were much low, but the resolution plan which came was actually 2.5 times of the actual valuation which were done. for the company. So this again, so it may be a very beautiful, say for example, I'm just very hypothetical right now. A palace which is in between the desert. It may be very beautifully built, or a lot of expense has been. So physically, the asset may be very, very of value. But if there is no accessibility, there's no water, there's no electricity, and people cannot live in this palace, there is no use of that palace. So maybe for the buyer's perspective, the palace may not fetch enough value. So that's how I say that the valuation are very, very, I would say, not for the purpose of valuers are very subjective, but from the purpose of selling any asset, the valuations can be very, very subjective, in the sense like if the person. So I'll give you another example of so I'm doing a program from Harvard, and there was this one company who used to make this spin brushes, and this company had started producing these spin brushes in a very low cost, and it was eating the market very fast of the established brands like Colgate or Oral-B, whose spin brushes were of a very high cost. And this particular brand, so we were doing the case study of this brand, were actually sold. So the actual value of that brand, or the company, or the manufacturing setup, or the distribution setup, was, say for example, only 10-20 million, but the company was sold into 400-500 million, because the brands who were operating in this space wanted to kill the competition, and they paid this price to this particular brand to buy this company, so that their market does not get disrupted. So as I said, that the valuations are very, very uh, critical to, in the eyes of the buyer, like what they are ready to offer. But obviously, as much as objectivity an insolvency professional or the valuer can bring in to value the company for the buyers, it's better for their own sake. But ultimately, at what price a company is sold in a going concern, in the process of CIRP, or in the liquidation, is totally depending on the market conditions of that particular asset or the company. So concluding my presentation, that yes, valuations are very, very important and a critical part, or very important part of the whole CIRP process, and a very important pillar. And valuers need to be very independent and diligent in their, and skilled, technically skilled, to do the valuations, and they should consider all the aspects of any valuation while they are doing and they should analyze as much as data and information they can to provide the valuation, and should analyze it in a proper manner. So I think that's about it. So although it is a very difficult situation, but still we need to be as sincere as doing our job as we can be. So that's about it. Thank you.
Some question.
So do we have any questions?
Ma'am, yeah, ma'am. Ma'am, first question is, in the
Hmm.
case where the court receiver appoints a valuer for a real estate project and asks the buyer who have paid in whole and have received possession for more than years pay an additional amount based on revised valuation. The buyer had bought some 15 years from the builder at an arm length agreed price. Can the court receiver and valuer challenge that?
So again, this to be decided by the court itself. I am not a judge. I cannot do that. But in my limited understanding, if you have, so I'm just dissecting the situations where I have bought the apartment, and I already on my apartment was completed, and I have possession of my apartments. So obviously I would not like to give this escalation, in my limited understanding, because obviously I have my But there's another catch which has happened in one of our cases is that the common areas were not built completely. Say, for example, the builder had proposed a club, maybe a swimming pool, or parks, or lawns, or the pathways, which were to be also built, and they are not built completely. So, in a prudent manner, or as a genuine person, it is possible that you may ask a certain amount to develop these areas, because now to create that infrastructure also the cost has increased. So it all depends on like how all the stakeholders in any process, or any in any situation, how all the stakeholders will come on one page, and how they will kind of interact. But I'm sure for the flat, no buyer would like to give any extra penny if he has the possession of the. If you don't have the possession, you don't have any choice, you will have to pay. But if you have the possession, I don't think anybody would pay. But it has happened in my experience for any. In fact, for the services also, people have given more money than what was kind of agreed upon, because now if you're living and you want some services to happen for you, you will pay more. Yeah, so it all
Okay, ma'am.
depends on practical aspects. Yeah, but
Okay,
legally I think you cannot bind anybody. Yeah.
okay, ma'am. And the next question is, can
Yeah.
valuation under IBC ever be truly objective, or is it is ultimately a function of assumptions?
So as I think keep saying this thing, because we all are humans, and humans cannot be I would say 100% objective. So some subjectivity element would be there, but it should not affect your integrity or your transparency. So whatever you are doing, if you have right reasons for doing that, you can disclose those reasons, you can document those reasons, then little bit of subjectivity element can be there, and it will be there. So 100% objectivity that is why we are called social sciences, right? Because 100% objectivity is not possible in my limited opinion. Yeah.
Next question is, ma'am, a company's own land that was purchased 20 years ago at a negligible cost, but is now located in a rapidly developing area. What practical challenges arise in determining its current fair value and liquidation value?
So I'm sure one has to consider now uh, the realizable value, like what is the market value now of that land. Obviously, in the land cases, it cannot be a 20-year-old valuation, which you would, kind of be considering. But at the same time, as I said, that certain aspect of that particular land should be considered, in the sense that the accessibility to that land, how it is that the transportation related matters, like for whatever the land would be used, whether it can be used for that purpose or not. Licenses, say for example, it is into an industrial sorry, residential area, and you want to start an industry, you will not get the license, or you will not get the permission to do the industrial activity in that area. So it is kind of dependent on many other market forces or market situations. But on and all these has to be considered while giving the valuation. So yes, the valuation will be current, not the old one, but at the same time, there are other factors which has to be taken care of while doing the valuation.
Okay. Ma'am, last question is, during CIRP, a manufacturing company has been non-operation for the last 3 years and several machinery are lying idle. Should the valuer adopt a going concern approach or the value the assets primarily on a realizable basis? What factors would influence this decision?
Yeah. So this is, I think, happening in most of the manufacturing cases, which came initially, especially in the CIRP. And I was dealing with one of these kind of manufacturing case where the company was shut in 2014, and I came as a IRP in 2018. So the factory was already shut down from last 4 years. So now the valuation will be according to, like, as I said, what is the probability of that machinery to be reused and what purposes? Say, for example, in my case, it was a paper manufacturing unit. And now, whether that machine, the kind of paper that machine is going to manufacture, is there a demand for that paper? One. And then, in how much cost this machinery will again be up and running, right? So sometimes the maintenance cost or reviving a machinery cost may be higher then, because now the latest technology is available and a new machinery may fetch or maybe cheaper than this machinery in the price which this machinery, because the parts now expensive or the machinery is like the maintenance is expensive, the oiling and the up and running condition, making the machinery in up and running condition may be more costlier than buying a new machinery. So it will go just as a scrap value, like as just selling the iron of the machine or something like that. So it will be definitely consequent to like at what this machine will be used for what purposes and what will be the maintenance cost of this machine. So obviously the valuation will be accordingly. Yeah.
Okay, ma'am. Questions are over, ma'am.
Okay.
Thank you so much for this wonderful webinar. Thank you for giving us time, ma'am. Thank you.
Thank you so much. I hope I have been able to explain the subject.
Yes,
Thank
ma'am.
you. Yeah. Thank
Thank
you
you.
for inviting me.